I want to talk about a kind of a crossover area, grand jury testimony. Grand jury testimony is under oath. Therefore, it would be good later on to impeach somebody, but also be able to use substantively because it was under oath, right? However, grand jury testimony generally is inadmissible as former testimony. And you're like, wait a minute, grand jury testimony in the past isn't former testimony? Here's why. Think about that former testimony hearsay exception. There must be an opportunity to cross-examine the declarant. There must be an opportunity to cross-examine the declarant. Grand juries are secretive proceedings. It's the rare situation where the defendant knows about the grand jury, let alone is invited down with their attorney to cross-examine prosecution witnesses or put on witnesses and evidence of their own. Therefore, although grand jury testimony is under oath, it's generally not subject to cross-examination. Therefore, rarely is grand jury testimony going to be sufficient as former testimony. And remember, what's going to trigger former testimony? An unavailable declarant. So you're at trial, you have an unavailable declarant. Oh, but wait a minute. He testified earlier at a grand jury. It was under oath. But unless there was an opportunity to cross-examine, it's not going to be admissible today as former testimony. So see the way that those two kind of interact. You may see that come up in evidence or in criminal procedure.